Good afternoon and a very warm welcome to everyone attending the seminar this afternoon. We hope wherever you are and whatever you're doing, whether you're at work or at home, in the office or out, that you are keeping safe and well. We have a very interesting, I think, program for you this afternoon. My name's Scott Worthy. I'm one of the partners at Kylie Thompson Caseley, and we'll be having, I think, a very interesting seminar, including an updated seminar that we've updated today to reflect the recent announcements yesterday about the traffic light system. In terms of an overview, I'll be kicking off talking about the COVID-19 protection framework. Peter Kiley, another partner at KTC, will be talking about bonuses and incentives in the Holidays Act. Stephanie Bode, Laila Darwaza will be taking you through key cases from 2021. Andrew Caseley, well known to you all, I'm sure, will be talking to you about his speciality, collective bargaining. And finally, Anthony Campos will be taking you through a legislative update in terms of the big changes to the law this year. So let's start with the recent news of the COVID-19 protection framework. It was released yesterday, or some of the details at least were released yesterday. And essentially it's going to be known as, I think, the traffic light law or the traffic light system. It's going to be passed under urgency this week. Likely to come into effect either tomorrow or Friday. So what are the key points with the traffic light system? Firstly, there will be, if we look at the next slide, there will be a list of affected businesses. The government has said hospitality, events, gyms, close contact businesses, on-site tertiary education. Those businesses are going to have vaccinated workforces. The specified work isn't yet defined, so although we know some of the broad categories, we don't know any of the exact detail yet. That detail will come hopefully next week before the traffic light system is implemented on December the 3rd. The traffic light system or the changes to the Act also takes into account employers who want to mandate vaccination but are not covered under one of the specific categories. And we'll talk a little bit more about that as we go through. Now, the other thing that some of the changes do is make it clear that if people, employers, businesses are collecting information from employees or customers about their vaccination status, they can only use that information for vaccination-related purposes. If you try and use that information for an illegitimate purpose, then there's a fine of $12,000 or potentially 6 months imprisonment. I think this has been introduced to try to allay fears that people's private medical information might be abused. So if you look at the next slide, the government has introduced, or is planning to introduce, and will from about mid-December, it says, a simplified risk assessment tool for businesses. You'll see there the basic framework they've set out. The result is that there are 4 categories or 4 boxes to tick. And if you get 3 of the 4 boxes, then you may be in a situation where you may be able to require staff to be vaccinated. At least that's the risk assessment guideline the government is now giving. Now, you'll see that this is a fairly blunt tool. Many businesses, and perhaps many of you out there, have done a far more sophisticated risk assessment than this already. If you have, the government says that's fine. You can rely on your own risk assessment. But this is a sort of prototype basic risk assessment that might work out well for small businesses, for example. And you can see one of the categories, for instance, is, are you providing services to vulnerable people? If you are, that will be a tick in the box towards potentially requiring vaccination for employees who work with vulnerable people. The government's also made clear that this tool might change, so we expect to get more detail and more information about the tool as we move into December. The other significant changes are really about termination of employment in terms of either a situation where, if we look at the next slide, either a situation where the mandate applies to you, in other words, you're one of the groups covered by the new traffic light system where you must be vaccinated to perform your job, or you're already covered by one of the other public health orders, like a health worker, for example, or in a situation where the employer mandates it. So the employer has done its risk assessment, gone through that process and said, we want to mandate vaccination for our staff. In all those situations, these new rules will apply to you, a business, an employer, if it wants to terminate an employee's employment. The first thing that should be mentioned, of course, is that the law will require reasonable time off for vaccination, and that's an important step, although I think everyone's been doing it already. The second thing it does is it puts in place a notice period and some other requirements if an employer wants to terminate employment for not fulfilling a government mandate or not fulfilling the employer's policy. So if you look at the next slide, the rules that are going to be put in place are that if an employee is unable to comply with the requirement, so they're not vaccinated, for example, then the employer can give notice of termination of employment on 4 weeks' pay. So what the new changes seem to require is that the employee is given notice and is not paid in lieu, rather they get the 4 weeks, and during those 4 weeks they are paid. Before giving that notice, the employer has to ensure that all reasonable alternatives to termination of employment are explored and assessed and found not to be available. The employee then gets the 4 week notice period, and if he or she changes their mind, great. The notice is automatically rescinded and they can come back to work. And the important point here is it's not retrospective. So if employees have been given notice already before this law comes into effect, then these rules don't apply. Instead, all those requirements probably of consultation and discussion will still be in place. And of course, employers should consider redeployment, for example. But the 4 week notice period rule doesn't apply if notice has been given before this law comes into effect, which will probably either be Thursday or Friday this week. So that's a quick run through of the traffic light system. There's much more to say, I'm sure, and much more detail to arrive from the government. But at the moment, what we have is a framework. The government will no doubt fill in more of the details as we get into next week. And in terms of the risk assessment, in the middle of December, they have said that there'll be more detail about that risk assessment. So that's all from me, and I'm going to turn over to Peter Kiley, who's going to talk to you about bonuses and incentives under the Holidays Act. Peter.
Thanks very much, Scott, and good afternoon to you all. I am going to address the issue of bonuses and incentives under the Holidays Act. Why have we included this one today? That's because there was a very recent case of the Court of Appeal which has clarified what the obligations are on bonuses and incentives and whether or not holiday pay is payable. On the screen, you'll see that in my 9 minutes, I'm going to address 6 issues for you, and I'm going to go straight to the first one. What actually is the issue? Well, you know, under the Holidays Act, the obligation on a company is to pay 8% holiday pay, depending on the individual's employment agreement. It might be greater if they're entitled to more than 4 weeks. And the issue arose for those people who were lucky enough to get bonuses or were on a commission system or they got an incentive. And I'll pick a figure just by easy explanation, say $10,000. Does the employer have to pay holiday pay on top of that? And the calculation, as you'll all be aware, it's gross earnings. So were the payments required under the employment agreement to be made? Now, a company called Metro Glass was challenged by the Department of Labour inspector for not having paid the additional 8%. And the figures can be very large. So the starting point was Section 14 of the Holidays Act and gross earnings. And that's on your screen now. And the statutory definition of gross earnings is all payments the employer is required to pay under the employment agreement. But if you look at Section 14B, it specifically excludes any discretionary payments. So you can see the issue, whether or not the bonus, the incentive, the commission, whether or not it was discretionary or actually payable under the contract or not, was a key issue. And if you go to Section 5 of the Holidays Act, a discretionary payment is very much defined under subsection A there. It means a payment the employer is not bound to pay. And it doesn't include the obligation unless it's required under the employment agreement. So that was the issue that came before the employment court for the well-known company Metro Glass. And the employment court looked at the wording of the Metro Glass clause, and it had lots of words like it's subject to board of approval, it is discretionary, and even if you hit these targets, we still reserve the right to actually pay it. But the employment court's judgment, when it looked at Section 14, said, in simple terms, Section 14 captures all remuneration and really only reserved or carved out of that discretion was when a company or employer said without any parameters at Christmas time, for example, we're going to pay everyone $1,000. Otherwise, if there was an incentive scheme, basically of any sort, that were designed to incentivize performance, they were captured under the definition of gross earnings. So that created a real headache for CFOs and accountants and auditors, because it essentially meant almost any payment designed to reward or incentivize would have to be included in gross earnings, and then the 8%, 10% or whatever holiday pay would have to be included. So as I've just said, only truly discretionary payments of the unexpected Christmas bonus wouldn't be included. Business New Zealand, it calculated that as a result of this Metro Glass decision in the employment court, there would be hundreds of millions of dollars of back pay owed. And they sought in the Court of Appeal intervenor status, which is rarely given, but they said we affect and represent wider business in New Zealand, and this issue affects basically all business, and they intervened, and Scott and I represented Business New Zealand in the Court of Appeal, in which we argued for Business New Zealand that discretionary bonuses and incentives, if they were genuinely discretionary, they weren't caught within gross earnings. So the court had a good look at the metropolitan clause and the paperwork and the wording. And the court said, well, you look at the wording that Metro Glass had, it wasn't just labelled discretionary, it retained a wider discretion not to make any payment. And the wording the court interpreted it wasn't neither guaranteed nor conditional. And in terms of what the statute means about discretionary, it felt squarely in that discretion and overturned the employment court's ruling. Now, that was a great relief to auditors who had provided for it in the accounts, and of course a lot of companies where if it had been upheld, the decision, there would have been a great liability. So what does that all mean for you? Well, in your individual employment agreements or in your bonus schemes, if you have them, you really need to look at the language and see that clear discretionary language is used. There's no such thing as a template. It's got to be quite specific. And if you don't want a guaranteed entitlement to payment, even if targets are hit, that needs to be clearly stated. As an overall exercise and obligation of good faith, there has to be full information to the employees, and good faith applies to the discretion. So what's going to happen to the back pay if there is any? Well, the lesson of the Court of Appeal case, and I should say we're not out of the appeal period. I haven't heard it will go to the Supreme Court. I'd be surprised if it did, but it could. There's 6 years for a limitation for anyone to bring a claim. A real interesting question is you're thinking, well, what about those companies that paid out on the employment court decision, effectively overpayment? That can be claimed back. You've got 6 years to do it. Whether or not you would want to is a matter of discussion. The final point I want to make is that the government 3 years ago established a holidays review committee, and one of the recommendations it made was that all payments, however made, discretionary or not, should be included in gross earnings. So it's possible that this Court of Appeal case could be amended and affected by parliamentary reform of the Holidays Act. Again, it's a matter of watch this space. So a technical matter, but can be quite big money and quite a liability for companies. So that's my 9 minutes. I'd now like to move on to Stephanie as the next speaker, and she's going to look at the tricky issue of independent contractor or employee, and she's going to look at the latest on workplace investigations. Stephanie.
Thanks, Peter. So as Peter has said today, I'm going to go through 2 cases of interest from the Employment Court over the past year. The first being the Uber case, which you might have heard about already, and that involved the age-old question of whether someone is an employee or whether they're a contractor. And the second case is the Smithson case, which explores a workplace investigation. So on to the first case, the Uber case. This judgment is interesting as it's in a line of cases about whether a worker is classified as an employee or not. This is important because if the person in question is found not to be an employee, they aren't able to bring a personal grievance claim. If you attended this presentation last year, you will have heard about Leota and Parcel Express, whereby a courier driver was found to actually be an employee, despite the contractual arrangements which stated otherwise. In this present case, the person in question was a driver for Uber, and the result was quite the opposite. So the driver here was involved with Uber in Auckland from 2015 until 2019. When he began, he entered into a services agreement with Uber, not an employment agreement. Uber was not deemed to direct or control the driver in his performance under the agreement, and he logged into the Uber driver app at varying times of the day, on different days of the week, and for different amounts of time. In 2019, Uber deactivated the driver's access to the driver app due to a complaint from a passenger, and the driver said he had no knowledge or details of the complaint and was given no opportunity to respond. So following this, the driver applied for a declaration that he was an employee of Uber so that he could bring a personal grievance. So turning to my next slide, the Employment Court was tasked with determining this key question of whether the driver was an employee or not. So the first thing the court looked at was the definition of employee under Section 6 of the Employment Relations Act. Under Section 6, subsection 2, in deciding whether a person is an employee, the court must determine the real nature of the relationship between them. So for the purposes of this, all relevant matters must be considered, and this is an intensely factual inquiry. So the court looked at several factors in determining the real nature of the relationship here. In brief, these factors relate to the written and oral terms of the contract, any divergences from that in terms of how the relationship operated in practice, features of control and integration in the employer's workplace, and also the industry practice. So after applying the test, the court concluded in this particular case, the driver was not an employee, so he was not entitled to raise a personal grievance. So to summarise the court's reasoning, Uber's lack of control and direction in respect of the driver was a very important factor. And so was the fact that he could work in competition with Uber if he wanted and was not required to display Uber signage. But it's important to note that the court stressed from the outset that the inquiry was intensely fact-specific and it only deals with this particular driver's situation. So since this judgment was released this year in New Zealand, First Union and ETU are seeking a separate, similar determination from the Employment Court, but with the opposite result. So they're contending that drivers here should be considered employees. So this is a space to keep an eye on and is an area of case law that is still developing. So moving on to my next case today. So this is the case of Smithson, and it centres around a workplace investigation at Wellington College that was challenged by a teacher. So this case contains some good tips on how to conduct a fair workplace investigation. The facts are quite extensive, but essentially a serious rift developed between two teachers in the English department over the allocation of classroom laptops. After a formal complaint was made by one of the teachers, an internal investigation was carried out, resulting in the recommendation to go to mediation. But this never ended up happening due to the severity of the relationship breakdown between the parties. And the college decided to appoint an external investigator to assess the situation and recommend solutions. Mrs. Smithson ended up objecting to the resulting report, and she raised a personal grievance for unjustified disadvantage. So moving on to the next slide, I'm just going to go over some of the more interesting aspects of the court's reasoning to keep it brief, because it's a 62-page judgment and is highly detailed. But overall, the court was not persuaded that any aspect of Mrs. Smithson's grievance had been established, and so her challenge was accordingly dismissed. So the first issue there is terms of reference. So commonly terms of reference are prepared at the very outset of the investigation and given to the employee to comment on. But in this case, the terms weren't provided to Mrs. Smithson, and she claimed that this lack of consultation was unfair. However, the court disagreed and found that it had already been made very clear in the information provided to her what the investigator would do. So the fact that there was no formal consultation as to the terms was not actually a fatal flaw. So in terms of practical guidance, it shows that if the terms of reference aren't provided to the employee first to comment on, this may not be fatal if the issues are already clear. However, consultation on the terms of reference may still be advisable to err on the side of caution and will always depend on the specific situation, of course. The next issue there is the decision to externally investigate after the internal investigation. So the court found it significant that the external investigation was motivated by the college's desire to re-establish a harmonious working relationship rather than it being a disciplinary process. The court also found that the appointment of an external investigator was taken very carefully in consultation with the chair of the Board of Trustees and another member of the board who was a lawyer. So in the circumstances, the court found the decision was a fair and reasonable one to have made. And the next one is the provision of information. So Mrs. Smithson alleged that not all documents requested had been provided to her. 2 had been missed out. And the court agreed. However, it found that the fact that she was not provided with these 2 particular documents wasn't a breach of natural justice because they contained no substantive content that was not already apparent to her. So although it's not an ideal position for the college to be in really, as they should aim to provide everything, it demonstrates that in certain circumstances it might not be necessarily fatal if documents requested and not provided contained no substantive content or information that was not already apparent. And so lastly, predetermination. In addressing this allegation, the court noted it's well established that it's not objectionable for an employer to form a tentative view during the course of an investigation process, which may have been the case here. So I think to sum up, a key message from this case is that at each stage in any type of workplace investigation, the employer must ensure that each action being taken is something that a fair and reasonable employer could do in the circumstances, and it pays to keep that in mind as you move throughout the process at each step. So here, Wellington College was able to show this despite some minor procedural hiccups, and they defended the claim. So that's a brief overview of that case and the Uber case. I hope that's helpful. And now I'll pass you over to Laila, who will be discussing some interim reinstatement cases from the past year. Thanks.
Thanks, Steph. For this section of the case law update, I'll take you through 2 interim reinstatement cases that have come before the Employment Court this year. These judgments are particularly interesting to read together, as in both cases, the employee was dismissed on the grounds of incompatibility. While this is one of the grounds that an employer can dismiss an employee on, it is only available in rare circumstances. Turning to my first slide, under the Employment Relations Act, an employee that has been unjustifiably dismissed can apply to be reinstated to their position as a remedy. Reinstatement may be granted if it is practicable and reasonable to do so. In 2018, the Act was amended to make reinstatement the primary remedy in unjustified dismissal cases. An employee can also apply for interim reinstatement, meaning that they would be reinstated to their role while awaiting the outcome of the substantive hearing. The first case I will take you through is Humphrey and Canterbury District Health Board, decided by the Chief Judge of the Employment Court in April this year. Dr. Humphrey was employed by the DHB for 20 years. In late 2019, a number of his colleagues raised concerns regarding workplace relationship issues with him. The DHB appointed an external investigator, Honorable Kit Toogood QC, a former High Court judge, to investigate these concerns. He issued a report on his findings, referred to as the Toogood Report. The report found that the DHB had failed to adequately address the relationship issues at an earlier stage, and that while some relationships had become untenable, the breakdown was not irremediable. The DHB then began a disciplinary process with Dr. Humphrey based on its concerns of incompatibility. During this disciplinary process, Dr. Humphrey advised the DHB that he wanted to look at options for improving his relationship with his colleagues and referred to one option that was identified in the Too Good report, which was seeking professional assistance to help fix the working relationship. The DHB did not utilize this offer, and Dr. Humphrey was eventually dismissed on the grounds of incompatibility. Looking at the next slide, you'll see 3 steps that the court must go through to determine whether to grant interim reinstatement. The first, whether there is a serious question to be tried, also known as whether there's an arguable case, is described as having a relatively low threshold and can be broken down into 2 sub-questions. In addressing the first sub-question in this case, the Chief Judge considered the steps taken and lack of steps taken by the DHB before and after receipt of the Too Good report, and found that it was likely that the DHB's process did not meet the standard of procedural fairness that is required. When considering the second sub-question for permanent reinstatement, the Chief Judge found that the DHB had failed to explore all options for repairing the relationship, specifically the options provided in the Too Good report before Dr. Humphrey was dismissed. Overall, there was a serious question to be tried. In weighing the balance of convenience, the Chief Judge considered Dr. Humphrey's specialist skills and the need to upkeep those skills by being at work. She considered other factors, including the likely merits of Dr. Humphrey's substantive claim and the extensive human resource capabilities the DHB has available, as well as Dr. Humphrey's willingness to constructively move forward with the employment relationship. The balance of convenience weighed in favor of interim reinstatement. Turning to the overall justice, the Chief Judge considered Dr. Humphrey would suffer from a professional perspective if he were not able to return to work, and that damages in these circumstances would not be an adequate remedy. The overall interests of justice favored the grant of interim reinstatement, and reinstatement was ultimately ordered on an interim basis. Since the conclusion of this case, Dr. Humphrey has resigned from Canterbury DHB, but as you can see on the next slide, in her judgment, the Chief Judge made some important observations about the 2018 amendment, which returned reinstatement to the primary remedy. In the judgment, she also refers to statements made by the Minister of Workplace Relations and Safety when introducing the amendment. He stated that the change in law was to provide a focus on how to restore the relationship rather than a focus on financial considerations only. The Chief Judge's comments suggest that the authority and the court should take more convincing than in the past to rule out reinstatement as a remedy. Turning to my next case, Christensen and Fonterra, decided in August this year. The facts of this case are that Mr. Christensen was employed by Fonterra in 2012. Issues began to arise between him and some of his colleagues after he shifted into a leadership position in 2018. Further conflict arose at the time of the initial New Zealand lockdown in March 2020, and Mr. Christensen agreed to work from home. During this time, he prepared a bullying complaint against a number of his managers and other team leaders, which went back for a period of 2 years. Fonterra was in the process of investigating the complaint in May when the lockdown ended. However, Mr. Christensen was told to remain at home until the investigation into his bullying allegations was completed. The investigation was finalized in September and concluded that the incidents of the complaint did not amount to bullying. Mr. Christensen did not accept the outcome of the report. He raised a disadvantaged grievance and sought mediation. Following 2 mediations where the issues were unresolved, Mr. Christensen proposed a detailed return to work plan. However, it was Fonterra's view that the return to work plan did not have the ability to repair the broken relationships, and Fonterra did not suggest any amendments to the plan. Ultimately, Mr. Christensen was dismissed for incompatibility. In the authority, Mr. Christensen was granted interim reinstatement, but only to the payroll and not to the workplace. He applied to the court to be reinstated to the workplace, stating that it was not just about the money. Turning to my next slide, and determining the first question on the slide, the court found that there was a serious question to be tried. On the second question, the court noted that in weighing the balance of convenience for interim reinstatement applications, it is necessary to balance the effect of an employee's continued absence from the workplace against the extent it can be rectified if the employee succeeds in the substantive hearing. The court considered that in most circumstances, dismissal has a financial impact on the employee. However, Mr. Christensen had already been reinstated to payroll. Also, there was no suggestion that he could not find other employment, but his main concern was that there was no alternative employment comparable to Fonterra's terms of employment. Most significantly, the court considered Mr. Christensen's concern that the longer he was out of the workplace, the harder it would be for him to rebuild relationships on his return. However, evidence given by Mr. Christensen's own expert was that a managed transition while legal proceedings were unresolved could be detrimental. This was important evidence that the court in Humphrey did not have, which made for a real difference between the cases. The court concluded that the balance of convenience did not support an order for interim reinstatement. Standing back and assessing the overall justice, the court considered that Fonterra did not constructively engage on the development of the return to work plan, despite it having significant internal resources to do so. The court distinguished this case from the Humphrey decision, noting that Mr. Christensen was still on payroll and that his concerns about favorable employment terms of Fonterra could be addressed by way of damages. Additionally, Mr. Christensen did not face the same professional consequences and limited options that Dr. Humphrey would have experienced if he was not returned on an interim basis. Ultimately, full interim reinstatement to the workplace was not ordered, and Mr. Christensen was to remain on payroll until the substantive hearing. Looking ahead, it's already clear that the Chief Judge's observations in Humphrey about the reason that reinstatement is the primary remedy has made some impact on the court's decisions on interim reinstatement. A judgment that was published just yesterday, which granted an unvaccinated airport worker interim reinstatement, as you can see on the next slide, when assessing the balance of convenience in this case, the court took into account the Chief Judge's observations in Humphrey. After noting the unusual circumstances of the case, the employment court ordered interim reinstatement, but this was subject to the condition that the employee remain on leave awaiting an order from the authority. These decisions serve as an important reminder that if an employee successfully establishes a claim for unjustified dismissal, then the authority or the court must order reinstatement wherever it is reasonable and practicable to do so. I'll now pass you over to Andrew Casely, one of the partners here at Kylie Thompson Casely, who will take you through the collective bargaining update for this year.
Thank you, Laila. Yes, I certainly agree with your warning that when thinking about dismissals or potential dismissals next year, it is prudent to more greatly weigh the risk of reinstatement. It certainly seems to be where the court and the authority are heading. Anyway, we're going to change direction now and spend a few minutes having a whistle-stop tour of the crazy world of collective bargaining in 2021. The first point I'd like to make is that collective bargaining continues to be profoundly a public sector phenomenon. The collectives cover 56% of the public sector workforce, but only 7% of the private sector workforce. We spend a lot of time dealing with that 7%, and so it assumes a disproportionately large amount of our attention. But overall, still the vast majority of private sector workforces have either no or very little union involvement. The second really interesting point is that despite now 4.5, 5 years of a Labour-led government and now a Labour government, the unions aren't making a great deal of progress. In the public sector, collective coverage is actually falling. It's fallen from 61% to 56% of the workforce. And in the private sector, it's fallen from 9% to 7% of the workforce. The expectation was that the union movement would grow and prosper under a Labour-led government and then a Labour government, and that isn't what the statistics are showing at all. It should probably be a real point of concern for the union movement if they can't make progress even in the favourable environment they now have. They should be thinking very seriously about their business model. For most of the rest of what I'm going to say, I'll talk exclusively about what's happening in the private sector, because the public sector really is a world all of its own. In the private sector, only 8% of collective agreements are multi-employer documents. Virtually all agreements, 92%, are single employer documents, documents between one employer and the union or unions that it has in its workplace. Some of you may recall that in 2018, there was much argument about a proposed change to the legislation preventing employers from opting out of collective or opting out of multi-employer collective agreements. The unions have for a long time had a campaign to try and encourage multi-employer documents, and they did manage to get a law change passed that prevented prevented employers from opting out of collective bargaining for multi-employer documents. That change has had virtually no impact at all. The split between multi-employer documents and single employer documents has remained the same despite the legislative change. I think the next really significant point about what's happening in the collective bargaining world at the moment is, and I'll have the next slide, is that for a long time, longer term documents have been becoming much more common. 75, until recently, 75% of collective agreements had terms of 2 years or more. But that has changed dramatically in the last 12 to 18 months. In fact, of the documents settled since March 2020, more than half have been for only 12 months. And significantly, another 8% have been for less than 12 months. Those of you who are involved in collective bargaining will know that the collective bargaining process can be long, slow, difficult, and challenging. And the idea of doing a document for only 12 months, or even worse, for less than 12 months, is not something that employers would willingly do, because it means you're back in collective bargaining very, very shortly. Despite that, we are now in an environment where short-term documents are becoming vastly more common than they ever have been. And I think that's a nice segue into what is happening in collective bargaining and why it is that terms have been getting so much shorter over the last 12 to 18 months. If I can have the next slide. The main point is that, as you will all know, we are in a very rapidly changing environment. The first thing is that we've reached the end of that minimum wage runway. You'll remember that 3 years ago, the government announced that it was going to make progressive increases to the minimum wage. And so in 2018, we knew that in 2019, the minimum wage was going to be $17.70. We then knew that the minimum wage in 2020 was going to be $18.90, and in 2021, it was going to rise to $20.20. That certainty and that forward visibility has now ended. There is no indication about what's happening to the minimum wage next year. And of course, we're already in December. So if you're bargaining now, trying to predict where wage rates are going next year, you don't have that certainty that you used to have about where at least the minimum wage is going. The second very dramatic change is that quite obviously we have reached the end of the 0 to 2% CPI era, at least for the time being. In March 2021, CPI was 1.5%. By June, it had climbed to 3.2%. People desperately tried to explain that away as just a temporary quirk in the statistics related to COVID. But in September, the CPI figure came out at 4.9%, and it was abundantly obvious that it was not just a quirk or a temporary aberration. Of course, that makes a huge difference when you're bargaining for multi-year documents. For a decade or so, we've been able to confidently assume that CPI will be somewhere in the 0 to 2% range. You can no longer make that assumption, and so you can no longer guarantee when you're looking forward that a pay increase of 1.5% or 2% will be somewhere near CPI. It may well be less than half of CPI. We simply don't know. I think that was the uncertainty, I think, was amply demonstrated by the central government pay freeze that was announced in the middle of the year. You may recall that it was announced with a flurry of excitement and determination, and it lasted less than about a week before the government was retreating from it. And a lot of the pay movements in the public sector have clearly been well above zero and are likely to continue to be well above zero. If I can have the next slide. That new environment of uncertainty is having a major impact on bargaining. Bargaining is taking much longer than it has in previous years. The parties are beginning the bargaining in circumstances where they are far further apart than they have ever been. Furthermore, a lot of bargaining processes this year have been interrupted by COVID, and so various forms of online bargaining have been experimented with. The unions are often pretty unenthusiastic about that though, and so a lot of bargaining processes have been quite delayed because of COVID. I think the union resourcing problem continues to be apparent. They are struggling to attract and retain staff, and in one of the bargaining processes I've been involved in for the last 6 months, I've had 4 different union advocates on the other side of the table. And then I think there's a real problem about the unions being able to control their members and to get ratification done. I think the next thing is that we are seeing far higher settlements than we have been used to in the past. The average increase in all collective agreements was 4.9%. That was heavily skewed public versus private. In the private sector, it was only 3.5%, but the government is dragging the average up. There is also a much greater range of settlements. 18% of private sector settlements have been above 5%, and another 5% of settlements have been above 10%. And of course, we're also seeing short terms. So in terms of what we can expect in the future, for next year and beyond, CPI continues to be a major uncertainty, and that is going to push settlements up. It's also going to mean that we can expect shorter term documents because it's just too hard to read the future. I think there'll be some big pay equity settlements starting to come through and put upwards pressure on wages. There are significant labour market shortages all across the economy, and that's putting upwards pressure on wages. We were meant to be getting the fair pay agreements, and that was likely to put upwards pressure on wages, but that has vanished. As I've said before, we don't know what the minimum wage is going to be, and we don't know where the living wage movements are going to be. Then finally, I think it's interesting to watch with much more minimum terms being prescribed in the legislation, such as 10 days sick leave, and with continued upward movements on the Minimum Wage Act. I think the question about why you'd bother belonging to a union when a lot of these changes and benefits are happening by legislation rather than by negotiation will be an ongoing challenge for the unions. So with that very quick tour, I'll now hand over to Anthony to talk about the legislative changes.
Perfect. Thank you very much for that, Andrew. That was very interesting. So yes, as Andrew said, I'll take us through what will be our final topic of the evening before we open it up for question time. So 2021 has been yet another significant year for legislative change. The COVID-19 response has without a doubt been the top priority, as Scott spoke about at the beginning of our session today. But I'd like to walk you through some of the more interesting developments that we've seen in other areas. So I'll first talk about some of the new significant changes that are currently in force in the next slide. There have been 2 significant amendments to the Holidays Act. Firstly, the Holidays Bereavement Leave for Miscarriage Amendment Act. This clarifies that the end of an employee's pregnancy by reason of miscarriage or stillbirth is a ground for the mother and her partner or spouse to take bereavement leave for up to 3 days. The normal eligibility rules will still apply, but that amendment clarifies something that wasn't immediately obvious from the Holidays Act, and I don't think it will come as any surprise that Parliament passed it unanimously. The second amendment there is the Holidays Increasing Sick Leave Amendment Act. This came into force in July this year and increased the minimum statutory sick leave entitlement from 5 days to 10 days per annum. This change was really spurred on by the effects of COVID-19, but did reflect a trend in collective agreements and IEAs that were offering 10 days sick leave. So it's a good reminder to check your IEA templates, and if they still mention a statutory minimum of 5 days sick leave, increase that to the new minimum of 10. So moving on, the other change in force as of 1 April this year was the new minimum wage order. The adult minimum wage was increased from $18.90 per hour to $20 per hour. That's an increase of $756 to $800 per 40-hour week. The starting out and training minimum wage rates also rose from $15.12 to $16 per hour. So if we turn now to the bills which are currently sitting before Parliament, firstly, the Protected Disclosures Protection of Whistleblowers Bill. This bill would repeal and replace the current Protected Disclosures Act 2000. It clarifies the definition of serious wrongdoing and extends it to cover private sector use of public funds and authority. The bill would enable people to report serious wrongdoing directly to an appropriate authority at any time. And the bill also strengthens protections for disclosures by specifying what the receiver of the disclosure should do and set out the potential forms of adverse conduct that disclosures may face. So this bill very recently received its second reading, and there's a very good chance that it will become law at some point next year as it works through the process. Next is the Screen Industry Workers Bill, which is a bit of a special interest of mine. And while it may not apply to most employers, I think it's worth monitoring as it gives interesting insights into the government's broader legislative program. When we think about screen industry workers, the first thing that will spring to mind is Bryson and 3'6" case and the subsequent Hobbit law, which provided that film production workers are not employees. The Screen Industry Workers Bill wades right into all those issues. It creates a new definition of screen production workers and affirms that if an individual meets that definition and is not covered by an employment agreement, that is conclusive proof that they are not an employee. But interestingly, the bill also introduces a new model to allow screen industry workers to bargain for collective contracts at either entire occupational groups or at the enterprise level. And it would also introduce a good faith duty in those contracting relationships and require collective contracts to include minimum terms and conditions such as pay and hours of work. It also creates processes for resolving disputes in contracting relationships and collective contract bargaining. This bill has been awaiting its second reading for some time, over a year I think actually, so we'll see what happens to that in 2022. Also on the slide we have the Employment Relations Extended Time for Personal Grievance for Sexual Harassment Amendment Bill. That may not be the easiest title to remember, but nevertheless it would involve a very significant change to the status quo. As we all know, there's a 90-day time frame for employees to bring a personal grievance from when the alleged action occurred or came to the employee's notice. This bill would extend that time frame, specifically where a personal grievance involved allegations of sexual harassment, from 90 days to 12 months. That change is, of course, designed to reflect that it can be extremely difficult for people who experience sexual harassment to come forward and to allow them sufficient time to process what's happened to them before taking the required action. If passed, this would become the singular exception to the 90-day rule. The bill was introduced only very recently, and we expect there'll be some further developments next year. Finally, there are some other upcoming developments on the next slide, which the government has announced that it intends to make, but for which we are still waiting on some draft legislation to be introduced. First off, the government has announced a new date for a new 11th public holiday. This would be celebrating Matariki, which is when the Matariki star cluster rises and signals the Maori New Year. The timing of this holiday would be variable, but around the end of June to the beginning of July, with the 2022 date being Friday, 24 June. Again, we expect draft legislation amending the Holidays Act will be introduced at some point soon. Then we have the Holidays Act review, and Peter briefly alluded to this earlier in his presentation. The Holidays Act task force that was set up to review the Holidays Act finally had its report published in February this year. the government announced that it had accepted virtually all of the task force's 22 recommendations. In short, those changes wouldn't really amount to a paradigm shift, but will include numerous changes to the existing holiday entitlements framework, intended to make it clearer, such as revising the definition of gross earnings. Workplace Relations and Safety Minister Michael Wood has said that new legislation could be introduced at some point next year. And lastly, we have fair pay agreements, which is again something that Andrew was touching on. Back in 2019, the Fair Pay Agreement Working Group provided some recommendations on establishing a sector-level bargaining system which would enable unions and employers to negotiate fair pay agreements, setting minimum terms and conditions for all workers in an entire industry or organisation. That would be a paradigm shift, and as far as New Zealand's collective bargaining framework is concerned. It was in May this year that the government said work was, quote unquote, underway in drafting new legislation. So very much a matter of wait and see. So that was a very brief outline of where we've gone this year and where we seem to be going. Whether that's a bright new sunrise or a sunset, I will leave to you. And I'll pass it back now to Scott to take us through a couple of the questions that we've received.
Thanks, Anthony. Yes, we do have time for a couple of questions that have been asked. The first, I think, is what are our thoughts if a business doesn't want to use the COVID protection framework? And as I mentioned during my presentation, we've seen lots of health and safety assessments that have been done by businesses, and all of them have been much more detailed than the government one, or at least what we know about the government one at the present time. So if you've been using a health and safety assessment that's much more sophisticated, probably likely to be much better and also much more nuanced in terms of the roles and the description of the health and safety risk. So, keep using that. Having said that, if a business is going to dismiss because of the traffic lights, in terms of a business that is covered, like a gym, or if a business is going to introduce a mandatory vaccination requirement, then the rules about 4 weeks notice and those other rules that we mentioned will apply to you, even if you don't use the government health and safety risk assessment and you use your own. The other question we had was about, can an employee be stood down during the notice period? I think Andrew was going to have a go at answering that question.
Thank you, Scott. Because it's a health and safety issue, and because kind of by definition you're saying that it's not safe for the employee to be at work, it's hard to avoid the conclusion that you are going to need to stand the employee down. Obviously, that will be case specific and fact specific, and there may be circumstances where some part of their work can be safely performed, but it's only other parts of their work that can't, and you may be able to utilise some of that notice period by getting them to do safe work, if I can call it that. But the fundamental problem is if you're terminating because it's unsafe for them to work, it's logically inconsistent for them to then work out the notice period. That somewhat relates to another question that we've had about how an employer can stop an employee getting a 4-week paid holiday, but just by getting it, and then they get vaccinated on the very last day. It does seem rather hard to avoid that problem because the government has introduced this 4-week system. There is, of course, the option of requiring leave to be taken if you follow the proper consultation first, and if they have accrued leave entitlement, you might be able to direct them to take annual leave for at least some of the period. You've got to give them 14 days notice, so probably only for the last 2 weeks. I have also seen, again, some employers who have been able to find some work that can be safely done so that they can get some value out of the notice period. But it is certainly a risk that has now been created. perhaps I'll hand back to Scott.
Great. Thanks, Andrew. Thank you all for participating and viewing the seminar today. We really appreciate you taking the time to do so. We hope you've found the presentation informative. Of course, if you have any follow-up questions, please let us know and be in touch with us. And I wish you all safe, and if we don't speak to you, a happy Christmas. And thank you all for attending. That's all from us. Goodbye.